I'm injury attorney Justin Ziegler of JZ Helps, a Florida injury law firm. Today I'm going to be talking about the horrific incident that happened at the Seven Seas Lagoon at the Grand Floridian, which is owned by Disney. A 2-year-old boy was snatched by an alligator. What I'm going to be talking about is whether Disney may be liable and owe compensation to the family of the boy who was snatched, and now it's my understanding that he's being presumed dead. JZ Helps, a Florida injury law firm. I also wanted to mention this is not the alligator from the Disney case. In order to analyze and look at whether Disney may be liable, and I say may because ultimately it would be up to a judge or a jury, is to look at past cases that have been similar. And the one case in Florida that I'm aware of that is a little bit similar, the facts, it was a case from 1986 where the gentleman went out to help a couple people who were on a sailboat, or a few people who were on a sailboat that was stuck, and while swimming out there, an alligator attacked him and he was injured. The appeals court said that the sole cause of the gentleman's injury was his failure to obey and his disregard of signs. In the other case, the appeals court said that an owner of a property does not have to guard or look out for wild animals. That's the general law in Florida, and that will apply to the Disney case as well. However, unless two exceptions, one of two exceptions are met. So if either of these exceptions happen, then the owner does have to anticipate the presence of wild animals, such as alligators, and guard against them. The two exceptions are, number one, if the animal is not indigenous to the area that it is found in. So, for example, fish or alligators are generally going to be indigenous to the area that they're in, a lake or a body of water like that. The other exception is if the animal has been reduced to the possession of the owner of the property, which would mean essentially the owner of the property has really taken possession of the animal. Now, in the other case where the gentleman was attacked in the lake, the appeals court said two things. A, the alligator should be expected to be in the lake, and number two, the owner, operator of the property didn't reduce the alligator to its possession. So the court essentially said there was no case for that gentleman. Even though that case did not involve a private property, the court said that once the operator undertook the responsibility of opening and running that property, they were treated the same as a private property owner, which is why I'm going to compare that case to the Disney unfortunate accident that happened last evening. In the other case where the gentleman was injured by the alligator, there were, again, several signs there. Some of them said to do not bother the alligators, don't feed the alligators, and things of that nature. Also, the appeals court said the gentleman had been there, like I said earlier on, 25 or more times to the property and was aware of the surroundings. And again, the appeals court said that gentleman was expected to use his reasonable senses and read whatever signs are there. And the court said in that case that the combination of the no swimming sign and the alligator signs were enough that no duty existed on that operator, meaning they had no obligation, according to the law, to do anything other than have those signs there. So they were not at fault in that case. What's important to note about that other case that I've been talking about is there were 3 judges on the appeals court that decided it. Now, the 2 judges said there was no case at all, and that is ultimately the law for those particular facts. However, it's important to note that one of the judges, in what's called the minority opinion, which isn't law in Florida, but another judge can think his way, and all it would take is 2 other judges to have the same opinion as the minority opinion in a future case, and possibly the decision could have been different. And the minority judge said that even though this gentleman was swimming in an area that said no swimming, that the purpose of the no swimming sign in that particular case was to prevent swimmers from getting hurt from boats that were launching into the water. And that judge also said that when you look at, even if there's a sign like a no swimming sign, you look at what behavior is occurring on that property. Even if there's a no swimming sign, but people are regularly swimming, that can go to the standard whether the operator owes a duty, has an obligation to watch out and protect its guests. In that other case, the minority judge also said that the person who was injured had no idea that there were alligators there, and even if there were alligators there, he didn't know that they could pose a harm. Now, I mention these things because in the Disney accident that happened yesterday, I'm unaware of whether the parents knew that there were alligators in the lake or in the lagoon, or knew that alligators can cause harm. But first you look at the duty of Disney in this case. In that case I was talking about, the minority judge said that the operator of that lake had a duty to warn about the alligators because they knew or they may have had a duty to warn about the alligators because they knew about the alligators. They knew about the dangers that the alligators can cause, and they actually had on several occasions removed alligators from that lake. As we look at the very unfortunate accident that happened last night, some of the things, if a lawsuit ends up being filed, that are going to come into play are, although Disney allegedly had signs that said no swimming, if there's a sign that did not give any warning about alligators in the lake, there's a chance that a judge could say that Disney owed a duty to warn of alligators in the lake. This would be particularly true if the evidence turns out that Disney had removed alligators from this lake or was aware that alligators were being removed from this lagoon, if people are regularly swimming in this area. And in any negligence case, in any personal injury case, what you do is if the defendant is at fault, you then look at what is the claimant, the person making a claim's fault. In this case, although the child has passed away, it would be the family, but still we would look at the percentage of negligence of the child. Now apparently was 2 years old, so he in Florida is 0% at fault because he's so young to appreciate it. However, if the case goes to lawsuit, I anticipate that Disney is going to place blame on the parents, and the percentage of blame on the parents for failure, if any, to watch the child more closely would reduce the entire verdict, the entire award. So let's say the parents were found to be 50% at fault for not paying better attention and watching their child. The total jury award would be in half. If the parents were only 10% at fault, the entire award would be reduced by 10%. Another factor that's going to come into the play is, had these parents been to the property before and seen alligators? If they've had seen alligators before in the property, that is going to make the child's case more difficult. When I say the child's case, I mean their case for the wrongful death of their child more difficult. If there have been accidents involving alligators that Disney knew about prior to this accident happening, that could potentially help the family's claim against Disney. If there had been no accidents in the past regarding alligators, which I'm not aware that there have been any accidents involving alligators at this particular lagoon, that would help Disney. If a lawsuit were to get filed, I think this case could go either way. There's a strong likelihood that it would get dismissed before even getting to a jury, based on the fact that alligators are common in Florida. They're commonly found in lakes, and there was a no swimming sign as well, and an alligator, after all, is a wild animal. On the other hand, there is a chance that a judge could agree with the minority opinion in that other case that I mentioned and let the case go to a jury, and when the case gets to a jury, anything is possible. My prediction is that if this accident results in a claim or lawsuit, Disney will likely settle the case either before a lawsuit or during a lawsuit. I hope that helps better educate you on the law involving cases where someone is injured by an alligator or other wild animal in Florida. Please subscribe to my YouTube channel. Again, this is a horrific story. I have a 2-year-old myself, and it's devastating to even think about something like that happening to my son. But the purpose of this video was just to go over the law so you have a better understanding of it. Again, please subscribe to my YouTube channel. Please comment below. I'd love to hear your opinions and thoughts on what happened. Thank you so much.